Let's start with today's the 13th of December. Not a great day for former President Jacob Zuma. I have a feeling that, if he looks back at this date, the 13th of December, he won't be too happy.
No, historically, the 13th of December has not been a good day for the former president. Exactly today, a year ago, there were two judgments in the very same High Court relating to his challenge of the Public Protector's State of Capture report. And it was on two fronts. The one was his challenge of the remedial action, which included an instruction that he should establish a commission of inquiry within 30 days. And the other was a personal costs order against him for interdicting the report to begin with. So that was a year ago on the 13th of December. And this year, we have a distinct judgment dealing with criminal matters involving him in his personal capacity. But again, his arguments and that of his legal counsel, expensive as they may have been, has been obliterated by the judgment.
So we have the benefit of, a record here of people speaking about these matters that sort of helps us understand what we're dealing with. Let's start with the costs, right? I guess the first question will be, how much is he looking at in terms of costs? He's been in court quite a lot, hasn't he?
He has, and he hasn't chosen sort of poorly equipped counsel either. He's chosen sort of highfalutin lawyers who charge a pretty penny in order to provide their services. And in fact, our current sitting president reported back to the EFF in Parliament earlier this year when Julius Malema inquired as to what was the situation with paying Zuma's legal fees. Let's take a look at what the president had to say.
All right, we'll come back to that particular soundbite of President Cyril Ramaphosa, and it's important. But we can talk about the outcome from the case that was happening on this particular day last year. You mentioned the one court case, and I remember I actually attended that particular case that had to do with him sort of wanting to interdict the release of the report and also challenging the remedial action, which entailed him appointing a judge that will be selected by the Chief Justice, and he took issue with that. But there was also a personal cost order that came from that judgment.
Exactly, and there the judge president of Gauteng actually said that Zuma was ill-advised to challenge that, to challenge the remedial action in the Public Protector's report, and then to also challenge the personal costs order. And in the papers, which I've been looking through now again, he uses to justify that argument and that conclusion the fact that Zuma had, by the time he started challenging all of this, already indicated in Parliament and in a presidential statement that he would establish this commission of inquiry. When wasn't exactly clear by the middle of 2017, but he had given an indication that he would do so, and yet continued through the Stalingrad strategy to challenge the remedial action of the Public Protector's report and also the personal costs order against him. So what we're seeing today, Tulas, is the consequences of the Stalingrad approach to litigation, which goes back as far as 2004 in the criminal matters that are addressed in today's judgment, but also, of course, the judgment last year on the State of Capture report by the Public Protector.
Let's see if we can hear from the judge president actually about the advisability or otherwise of his challenge to the Public Protector's report.
All of a sudden become encompassed as confidential within the representations when in fact, if it isn't confidential beyond the representations, it's been declassified by the NIA, they've referred to it, but you've got a further problem. They tell you what it contains. Well, Mr. Kemp, once you've made the concession that there's no factual basis for the argument and you've conceded that then there is no argument, is there anything left to say?
Yeah. So that's not the sound clip we wanted, but it's one of the sound clips we had lined up, Erin, and this one is from the Supreme Court of Appeal. And I've always said that, as far as I know, most people get one crack at the Supreme Court of Appeal, and that's that. But former President Jacob Zuma had multiple shots at the Supreme Court of Appeal. But in this particular clip where we saw Camp being asked about whether there's any substantive arguments that he's presenting, and that concession that there's none, that became a hallmark of his litigation strategy, didn't it?
It did, and it's in the judgment from December of last year in the State of Capture report challenge. challenge by then President Jacob Zuma. And the judgment finds that there weren't merits to the argument that he had supreme power to appoint a commission of inquiry, and there was no role for the public protector to advise that in this matter, because the president would be conflicted, that the Chief Justice should be given the responsibility of choosing who would head up that inquiry. And so this clip that we've now seen from August of 2014 gives us a taste, back then even, of this kind of approach of going to courts repeatedly, whatever the merits may or may not have been, and then trying to push through all the way to some kind of judgment in his favor. And what's the point? The point is that the state, taxpayers, the people of South Africa were bankrolling it. And what's the problem there? Well, you know, some taxpayers might be sitting in plush suburbia, but the judgment from today makes it very clear what the cost of this is. And it says that these criminal prosecutions have a consequence in terms of service delivery to the people of the country. If you're spending, what we heard from the current president in March was around 15 million rand in legal fees over 3 different periods for the former president, that's 15 million rand at a conservative estimate that could have gone to pit toilets, that could have gone to service delivery, water, sanitation, housing, all of the kinds of things that are instituted in our Bill of Rights and in our Constitution as fundamental to the livelihood of South Africans. And it was going to paying silks.
Especially when you consider that today's judgment talks about it not complying with National Treasury regulations as well as the State Attorneys Act. Erin Bates, thank you so much for coming through and giving us those insights into today's judgment coming from the High Court.